Hello, everyone. My name is Susanna Kuuttila. I'm the teaching assistant for the Create Cell Bank class that teaches innovation, e-commerce, and idea pitching. And I'm here today to talk to you about intellectual property and to just kind of give you a one-on-one overview of the different types. So again, as I mentioned, what we'll be going over today is the 4 different types of intellectual property. So this includes patents, copyrights, trademarks, and trade secrets. And I'll be going through each one in a little bit of detail. So before I get started, I just want to mention that all the information that I'm presenting in this PowerPoint can be found on the USPTO website, the U.S. Patent and Trademark Office, which is www.uspto.gov. So we'll start with patents. So patents essentially protect an idea that you may have, a new type of invention. There are 3 types of patents. The first is utility patents, the second is design patents, and the third is plant patents. I'm going to go through each one of these a little bit in greater depth to describe what can be classified under each one. So the first, utility patents. There are 4 categories that fall under this. So a process, which is a process, act, or method of doing or making something. So this includes a lot of industrial or technical processes. The second category is a machine. So this is any type of machine. It can be a computer, a clock, anything that functions in a certain way. The third category is a manufacturer. So this is anything that is made. So this includes a table, a chair, a bed frame, anything essentially that you can manufacture. And the fourth is the composition of matter. So this is a new chemical composition or a mixture of ingredients or a new chemical compound. So this can include, new formulations for soap or shampoo, and it can also include, pharmaceuticals or new types of drugs, things like that. And the life of a patent for utility patents is 20 years from the date on which the application for the patent was filed. And this is an important distinction. So patents, they typically take about a couple years with the U.S. Patent and Trademark Office, corresponding with either the attorneys or the inventors that directly themselves through the form of office actions. And from the initial filing date, that is actually when the 20-year clock for the life of the patent starts. It's not when the patent actually issues, which is a common misconception. And this is important to remember because once that time frame is up, the patent or the idea is out in the public domain, so it can be used by anyone. However, it cannot be claimed solely by anyone else to exclude anybody else from using it. I'll move on to design patents. So design patents essentially protect the way an article looks. So it's the ornamental characteristics of a design. So it can be a new design for a lamp or a wall hanging, or in the case of an iPhone, the rounded corners and the flat screen, those constitute design patents. And a lot of manufactured items, which is one of the categories of utility patents, they possess both functional and ornamental characteristics, such as a chair, the way it looks, a table, the same thing. Both utility and design patents may be required to fully protect the invention. And again, this is something that, it's important to talk with an attorney about or somebody who is qualified in this area to really determine what would be the best level of coverage for your invention. In terms of design patents, the life is 15 years from the date of issue. And this is applications filed after 2015. So anything, as of now, if you file for a design patent, as soon as it issues, it's alive for 15 years and you're able to use it. The third type of patent is a little bit smaller category, but it's still there and still worth mentioning, and it's plant patents. So there's a couple different things that fall under this. Essentially, it has to be a newly discovered living plant organism, which can be duplicated through asexual reproduction, but cannot otherwise be made or manufactured. So this can be cultivated plants of a lot of different varieties, hybrids, mutants, or transformed plants. And it's important to note that algae and fungi are considered plants under this, but bacteria are not. And the life of a plant patent is 20 years from the date on which the application was filed. So it's similar to the utility patent. So as soon as that application is filed, that is when the life of the plant patent is started. So all these types of patents have to fulfill 3 requirements if they're to be issued before the U.S. Patent and Trademark Office. The first is it has to be useful. So essentially, the subject matter has to have a useful purpose and it has to serve its intended purpose. Each of these categories is broad on purpose because there are so many different types of things that can fall under this. But essentially what this requirement means is that if you claim that your invention does something, you just have to make sure that it actually does that. It's not necessarily that you have to completely reduce it to practice. So you don't have to completely, develop a working prototype and, have it implemented in systems. You just have to be able to prove in theory that your invention works. So for example, a perpetual motion machine, wouldn't be patentable because you would not be able to prove that it actually would work. So the second category is that the patent has to be novel. So this essentially means that it can't have been known or used, patented, published, described publicly, or on sale before you patent. So it's really important that if you want to get a patent on your idea, you make sure that you don't publish anything, whether that's in an online journal article or in a presentation that you're giving, whether it's in school or whatever else, or offered it for sale. So you want to make sure that you at least start the patent process before you disclose publicly. And if you don't, there's circumstances to where you can still get a patent, but it's important to, very, very soon after you disclose to either talk to an attorney or look into the patenting process. It's important to mention under this category that you can make improvements to another invention as long as it is not obvious to make those improvements. The third category is it has to be non-obvious. So essentially what this means is that it has to have a sufficient difference from what has been used or described before. So if you're coming up with a new composition for, hair conditioner, it has to be sufficiently different. It has to have a sufficient benefit, or, it's cheaper, it works better, it, uses a new compound. It has to be sufficiently different in that a person having ordinary skill in the area of your technology or your idea related to the invention would not find it obvious to make the change. So it has to have that inventive step in there. That's really all that is required for these. So in order to get a patent, to recap, you have to fulfill all of these three requirements. So moving right along to copyrights. So this is the second type of intellectual property, and essentially what copyrights do is they protect original works of authorship fixed in a tangible medium of expression. So there's a lot of different things that can fall under this. It can be, books in the form of literary works, poetry, novels, things like that. It can be architecture, so in the form of design of buildings, or it can be, music, songs. The main requirement is that it just has to be fixed in a medium. So whether that's, a song being recorded or written down on a piece of paper, whether that's, a poem being written down, it doesn't necessarily have to be published. It just has to be, recorded, or architecture, just at least the design plans, written out and, able to be viewed. So there's a lot of different things that can fall under this. And basically the manner and medium of fixation are unlimited. So it can be words, numbers, notes, sounds, pictures, or any other graphic or symbolic media. It doesn't really matter. It just has to be implemented in some way that it can prove that you have come up with this on your own. And again, you don't have to publish anything to have a copyright. As soon as you write something down or type something up or create something, take a picture, is copyrighted right then and there. You don't necessarily have to do anything else to it. The life of a copyright, there's been new legislation that's been passed in the last couple of years, and now the terms of the copyright for an individual, so let's say you yourself have come up with something, let's say, it's a poem that you've written. That poem would be copyright to you for your entire life plus 70 years after that. So it's a pretty long period of time to where you solely own that copyright and nobody else can use it without your permission. If the copyright was developed anonymously or for hire, so this applies to businesses or corporations, it is 95 years from the date of publication of the media, or 120 years from the date of creation, whichever is shorter. So it's funny, there's this special circumstance with Disney's Mickey Mouse. That's actually the reason for a lot of the recent legislation on copyright laws, because it's been very difficult for a lot of people to, have the idea of having Mickey Mouse out in the public domain. So these new laws have actually extended to where, Mickey Mouse is not in the public domain. It is still protected by Disney, even though it was invented in the 1920s by Walt Disney. But some other examples are William Shakespeare's works, which were in the 1600s. Those are out in the public domain now. And the works of Mozart, in terms of his music, both his recorded music and what he wrote down on paper, those are out in the public domain. Again, once something is in the public domain, nobody else can exclude others from using it, but anybody is free to use it from there on out. So again, you don't need to register your work with the Copyright Office to claim copyright. It's secured automatically when you create the work, when you write something down, when you compose a song and you record it, or you write it down on a sheet music. And again, an example could be, a song can be fixed in sheet music, on a CD, or both. It doesn't really matter how you record anything. It just has to be recorded in some way. Even though it's not required, it's recommended to register with the Copyright Office if you are going to be using it for business purposes, just for the following reasons. It creates a public record of your claim to the copyrights, so there's no question about, that it is your copyright, you came up with it, you are the author of that. And in cases of infringement, if somebody else is using your copyright, then you can, pursue that, and you have claim still to your work. And it establishes the validity of the copyright if there is ever any question about it. So we're moving right along to trademarks. So a trademark is a word, phrase, symbol, and/or design that identifies and distinguishes the source of goods of one party from those of the others. And another way of saying this is a service mark. And essentially it's the same thing, but for a service. And this is brand names, slogans, and logos. But we encompass both of these into the word trademark because, we just broaden it out and say that everything, goods and services, are a trademark. So below is an example of a number of different trademarks in terms of logos. So the Nike swoosh, that's a trademark. The Google logo, McDonald's has a trademark on their logo. Basically anything that can be used to identify the trademark and identifies it and distinguishes it. So registration of trademarks, again, is not mandatory, but federal registration of a trademark with the U.S. Patent and Trademark Office has several advantages. So there's, again, a public notice that you own the trademark. Nobody else can claim it. There's a legal presumption of ownership in case there is any infringement or anything. And you have the exclusive right to use the mark on or in connection with the goods and services set forth in the registration. So you are the sole owner of the trademark. You are the only one that can claim, the purposes that it excludes others from using. The length of the trademark is indefinite as long as the mark is in use. So that's very important. You can't just get a trademark on something and not really pursue the business afterwards. If you are using it for a business, it won't stay valid after that. And again, as with patents and copyrights, you do have to file specific documents and pay certain fees at regular intervals. And all of that information can be found on the U.S. Patent and Trademark Office website. They have a very clear schedule of the fees that are due and the amounts. If you're an individual, the fees are very low, just because, the U.S. Patent and Trademark Office wants to encourage inventorship and entrepreneurship. So again, each time you use your trademark, it's important to use a designation with it. So if you have registered with the U.S. Patent and Trademark Office, you can use the R with the circle around it symbol. That just means registered trademark. If you don't have it registered, or if it's not yet registered, it's in prosecution still, you can use the TM with a circle around it symbol for goods, or you can use SM for services. Or you can just use TM for services too. It doesn't really matter. And again, sometimes the use of a business name. So let's say you are filing for an LLC and you get an LLC registered on your business name. That doesn't necessarily qualify you for a trademark on that same name. You still have to, if you want to register your trademark, you still have to do that with the U.S. Patent and Trademark Office. And again, if you use, if the business name is associated with, distinguishing yourself from other competitors, and if you use it in that certain way, it can be considered a trademark if you use it to identify the types of goods and services that you provide. It can be. So if you develop a logo, that can be a trademark. It really just, has to in some way identify the purpose of your business. So moving right along to the fourth type of intellectual property, which is trade secrets. So trade secrets are a little bit harder to define because they're not public, and this is on purpose. So trade secrets consist of information that is unique to an individual or a business, and it must remain secret. So this can be anything from a formula, a recipe, a pattern, a program, method, a process, really anything and everything that you can think of. Trade secrets must be used in business in order for them to be valid, and they must give an opportunity to obtain an economic advantage over competitors who don't know or use it. So an example could be the recipe for a really good chocolate chip cookie recipe. That could be a trade secret if you use that for your bakery business. And what you would have to do is be very careful about, not disclosing that to anybody outside of your business. And that would have to be some sort of, documentation that your employees sign, that they, a non-disclosure agreement, essentially. This was a pretty famous case with Coca-Cola and Pepsi, to where Coca-Cola, of course, their recipe for Coca-Cola is a trade secret. Nobody really knows what it is, and it's like that on purpose. Coca-Cola is very, strict with their employees, that they have a non-disclosure agreement. They're not allowed to, disclose what that recipe is. But years back, Pepsi actually found out what the recipe was through, different uses of tactics, and Coca-Cola won a big lawsuit against them. So it's really important to, make sure that your trade secrets are protected. But if they are disclosed in a certain way, or if it's unauthorized, there is protection that, the U.S. Patent and Trademark Office can give you. So, if it is an unauthorized disclosure, there can be reprimands for the people who do steal that trade secret. But essentially, if you as the trade secret holder, if you fail to maintain secrecy, or if the information is independently discovered without any use of, unethical tactics, or if it becomes released in any way, the protection as a trade secret is lost. So it's very, very important that if you're going to do something like this, you have to make sure all the necessary precautions are in place. Again, trade secrets don't expire, so the protection continues until discovery or loss of the secret. So that's all I have today. If you have any questions, I am actually a registered patent agent with the U.S. Patent and Trademark Office, so I'm happy to answer any questions. Again, my name is Susanna Kuuttila, and thank you for listening.